Thank the team of ADRI and Gender Alliance, especially Prashanti, for making this event possible. I would now like to invite Dr. Saibal Gupta, Member Secretary ADRI, to deliver the welcome address. May I also request Justice Ajay Tripathi and Justice Anjana Mishra and Professor Catharine Mackinnon to join Dr. Gupta on stage, please. Deliver the welcome address.
Justice Tripathi, Justice Mishra, Professor Catharine Mackinnon, Dr. Ruchira Gupta, Dr. Ghosh, Satyajit, Sunita, Nisha Jha, Dr. Vijay Lakshmi, participants in the conference, enlightened intelligentsia, journalists and media persons. Ladies and gentlemen, it gives me great pleasure to welcome you to this historic lecture by Professor Catharine Mackinnon today. This will be a memorable event and a new benchmark in the realm of public oration and dissemination in Patna. We are treating this lecture as one of the ADRI Foundation lectures also. Professor Mackinnon's lecture was preceded by consultation in Patna today on child labor, sex trafficking, SDG 5.2 and the last girl. This consultation is part of a 3-city international consultation that Indian anti-sex trafficking organization Apne Aap Women Worldwide has organized in Delhi on November 23rd, in Kolkata on November 24th and 25th November, and last one is being held here in Patna. The Patna consultation is being jointly organized by Gender Alliance and ADRI along with Apne Aap. The aim of each consultation has been to highlight the vulnerabilities of the last girl and advocate for India to uphold constitutional and international obligations to them. The goal of the consultation is to create a campaign that will result in even greater awareness and actions for the last girl. We are happy that a person who brought this agenda on the global center stage, Ruchira Gupta, is here with us, and you have heard her very stimulating inaugural lecture in the afternoon. We are very honored to have with us, as well as throughout the length of the entire 3-city consultation, Professor Catharine Mackinnon. Please, can you just keep your mouth shut? Pioneered the legal claim for sexual harassment in the world, and an ordinance is recognizing pornography as well as civil rights violations are now the basis for legal framework in the USA and many other countries. She proposed the Swedish model for abolishing prostitution, which has now become the world standard for combating sex trafficking. The Canadian Supreme Court has largely accepted her approaches to equality pornography and hate speech. Representing Bosnian woman survivor of Serbian genocidal sexual atrocities, she won a Damage Award of $745 million, the first legal recognition of rape as an act of genocide. Her seminal work towards a feminist theory of the state has influenced generations of women internationally. Professor Mackinnon teaches law at the University of Michigan and Harvard. A new book, Butterfly Politics, has been published by Harvard University Press this year and is being distributed by Penguin Random House in India. The chapter on trafficking refers to her interactions with Indian anti-sex trafficking organization Apne Aap, Women's Worldwide Survivors of Prostitution. These interactions led to a successful Patna High Court order on Apne Aap PIL that provides one of the most critical and holistic framework to combat sex trafficking in the world. I am extremely grateful to Justice Ajay Tripathi for kindly agreeing to chair the session today in spite of his busy schedule. He has been giving us all support to Adri for the last 25 years of our existence. Incidentally, today is a working court day. We are also grateful to Justice Anjana Prakash for being present in the lecture in spite of a very busy schedule. Incidentally, we have almost 40 years relationship, and it's a present moment that she is with us today on this important occasion. I must thank Mr. Nadim Noor, Prashanti Tiwari, Tinku Khanna, Dr. Sunita Lal for organizing the event in such a meticulous manner. I must also thank Sandeep, and I am not seeing Sudeep of Adri to give organizational support to the event. We are organizing an Adri event for the first time in Lemon Tree Hotel. I am sure Mr. S.P. Singh will provide all the nuts and bolts meticulously. Thank you. And we are looking forward to the lecture of Professor Mackinnon. Thank you, ma'am.
Gupta, I would now like to request Manisha ji to present a token of appreciation to our esteemed guests. Thank you, Manisha ji. I would now like to invite Justice Ajay Tripathi to deliver his address.
Good evening, everybody. Surely a matter of honor for all of us to be here to listen to the address by Dr. Catharine, who is specially come all the way and is the fittest person to address the gathering on the topic of child labor and sexual exploitation and the inequalities which a girl child especially faces in society. We have limited exposure and experience as judges because we are not the people on the field we are working in some kind of a lab situation, in the sense that it is certain litigations which finally filter down before us, where the application of law and interpretation of law is done by us, which has fallout and implications for the issue brought before us at in that particular litigation. But then the problem for which we have all gathered here is a very big canvas and a very wide, diverse field of issues. And putting everything together and making all the system work to deliver towards one objective is not an easy task for any organization or any individual, because the facets of such exploitation has many dimensions, starting from the background, the society, the education, the financial background, social milieu, and the support system, coupled with the exploitative system which is in place. Fighting all this together, therefore, has to be a very concerted and a joint effort of every person or every individual or every organization or every stakeholder, and they have to work together as a unified team. So far as the Indian conditions are concerned, the existence of the problem, the magnitude of the problem is, we are all aware of this sheer size of the country with a population of almost 125 crores, half of which is naturally, almost half of it is consisting of the women population, and almost half of that of the girl child or adolescents. We can imagine the sheer volume. But then we have people who have taken it upon themselves, put in certain organizations in place with support of governmental organizations and framework, which is trying to contribute and make a difference. But we have a very, very humongous task and a long way to go, because my experience with an exposure to these problems is that law is not an issue in this country. We have one too many law. So it is not that the paucity of law is one of the reasons. It is the implementation and enforcement of the law in the proper letter and spirit, with the object of reaching out to the girl child for which the law has been created, in whatever field it is, being child labor, sexual exploitation, enslavement and trade, human trade, etc. All these aspects have to be gone into, and we need people with sensitivity of the kind to deal with these problems. A lot of times I have seen that even government organizations and bodies which are set up, people who are at the helms of affairs, they are not really very much aware as to what exactly is expected to be done. They treat it as a routine governmental duty, and the sensitivity part of it is missing. which takes away the entire effort behind the exercise or the object of creation of such bodies or these committees which are saddled with the responsibility in dealing with a girl child. I am sure Professor Catharine will be able to expose us to more ground reality and the actual working in the field, and I am looking eagerly forward to her address so that I can also get enlightened on how things are on the ground. Thank you. Thank you, Honorable.
Thank you, Justice Tripathi. I would now like to request Justice Anjana Mishra to deliver her address.
Thank you. Good evening to all, especially our revered guest, Dr. Catharine Mackinnon, Dr. Gupta, Professor Ghosh, and of course my brother Justice. It has been a matter of great pleasure for me to address this august gathering and also to be part of a lecture where Professor Mackinnon will be giving and enlightening all of us about the intricacies of this major issue, the girl child and the trafficking part of such children and women. We on the bench have very, very scant knowledge about the intricacies of what and the gory details of what really happens to women. It is, as my brother very aptly submitted, that these who work at grassroots levels alone can understand what is the pain and what is to be done about it. So far as I am concerned, as a lawyer, I was encouraged into knowing about this field from none other than the greatest exponent, that is Dr. Ruchira Gupta. She invited me to participate in this. You know, she had taken it up as an issue of her lifetime, and she has been working on it at grassroots level. She told me about how India was suffering under this terrible menace of trafficking. Children, women, small girls, and she also enlightened me about a very painful thing, which was intergenerational prostitution, which was going on in our country. That truly pained me, and I got encouraged into going further into the deep aspects of the matter. The Act and the laws which had been framed were there, but there was scanty application of such laws. How to go about it was nobody's business. So somebody had to come up and tell how it was to be implemented. So we got encouraged into filing a PIL here in Bihar, and the High Court took notice of this. What really gave us true happiness was that the taking up the issue, the state got spurred into action. They set up anti-human trafficking units. Then special police officers were appointed. Thereafter special courts have also come up. And now we are addressing this issue through proper implementation. At least in our state, I think we have gone a way forward than what it was 3 years back. So for that, I think the credit goes to Tinku Khanna also, who jumped and became the petitioner in the case. And she really took efforts to provide me all the material so that I could go and put it before the courts. And we got a very, very good order. The main thing that now we have to do is we have to address this issue on a larger canvas. And once it is done, I'm sure what Ruchira has dreamt of to the last girl, this menace will fade away. So I will not waste much time and speak more about this, excepting one thing, that we need to apprise our judicial system and train the officers in such a manner that they are able to implement the laws. And for that, I think the pioneer was Professor Mackinnon, who had framed a pattern in which judicial officers should be trained. And if that is followed, then I think in all the judicial academies, then I think it will be very, very helpful for all, and they will be able to implement the laws further. So with that word, and because I am more anxious to hear, not to hear myself, the sound of my own voice, but Professor Catherine, that I think I shall say a word of thanks to you and invite next speaker.
Thank you, Justice Mishra. I would now request Professor Mackinnon to take the dais. Professor Mackinnon is one of the greatest legal minds of our generation. She has pioneered the legal claim for sexual harassment. She has also proposed the Swedish model for abolishing prostitution, which has now become the world standard for combating sex trafficking. Professor Mackinnon, ladies and gentlemen.
Namaste, everyone. I'm especially pleased to be back in Bihar, where, with your tradition of the pursuit of social justice as a priority, and the tremendous learning that I have gained from working with the organization Apne Up, with your daughters, Ruchiraji, with Tinku Khanna, and with all the women and girls and men that they work with against sex trafficking and intergenerational prostitution, in particular from the Nat community of Kawaspur, from whom I have learned so much. All of our valiant colleagues there are the ones who have made it possible for us to know the way this menace operates. And thank you also for the informative contributions that everyone has made to this consultation so far, and for everyone's patience in waiting this long. What I would like to consider is the question of how one produces desired social change through the practice of law, through legal practice. And to do this, I'm going to theorize some of the legal and political initiatives that I've taken over the last 40-some years, and ask and attempt to conceptualize these interventions for social equality through law, that in terms of where they have gone, what the status is now, and where things should go or could go. So these thoughts will be focusing on strategic challenges to gender inequality, understood as a hierarchy of men over women, in an attempt to change the realities of sexual abuse on the ground. That has been the focus of this work. Shifting the politics of male dominance, that is, focusing on the larger context of unequal practices, including sexual harassment, rape, in and out of genocide, pornography, prostitution, and sex trafficking. What I have learned here, and what I think is really well known in Bihar, is these kinds of changes done both through law and in society are a collective effort. It's not an individual project. It actually takes a whole movement. Also, it is deeply contextual and grounded. It comes from the realities of social life, and in particular springs from the vulnerabilities of what Abniap has comprehended as the last girl. That is, the girl whose combination of caste, class, age, and finally gender makes her the one who is most vulnerable to being sexually violated, both in systematic forms such as prostitution and in individual forms, including within her family. I'm enjoying the music, but could we possibly turn it down a little bit? Wonderful, thank you. So the kinds of social changes that we all work with come from the realities of social life and relationships, not from the inspiration of any individual person's mind. And also I've learned that in this work, it is totally contingent. By this I mean, nothing in it is inevitable. You know, if you accomplish something, there are always, I mean, you can spend 20 or 30 years on it, and there are always people on the left ready to tell you that the moment you've accomplished it, it was inevitable. Thanks a lot. At the same time, the whole time you're working to accomplish it, people on the right will tell you it's impossible. They imagine that it is, or I think hope that it is impossible. I say this only to highlight the point that it actually does matter what you do. It's neither inevitable nor impossible. It's contingent on your actions. And the other thing I've learned is that all of it is based on content. You listen to law professors talk and you would think that a lot of it was abstract somehow. But actually it is substantive. And whether change happens or not, all turns on the right intervention, even if it's a very small one. So what I want to talk with you about is one way I've devised to think about what is the right intervention. I'm thinking about it in terms of the image, which is the title of this new collection of my activist work. All of this activist work has been what I've kept out of all my previous collections. You know, the things that just had the wrong kind of voice, or was just a little bit too engaged for whatever else was in the book. And then I realized that it actually was a collection in itself. So in this activist collection, it's centered on the answer to a question that the zoologist Konrad Lorenz asked in 1972. His question was, does the flap of a butterfly's wing in Brazil set off a tornado in Texas? And when he answered yes, actually, it can and does, he created what has come to be known as the butterfly effect. This charmingly models how some extremely small, simple actions, if they are properly targeted into the right kind of environment, can come to have highly complex and large, even cataclysmic effects worlds away. The larger theory of which this is a part is called chaos theory. It doesn't mean things are chaotic, it just means that patterns are very complicated. It's a way of understanding complex causation in dynamic, unstable systems. Weather, for example, these days, is predicted far more accurately as a result of the application of chaos theory. So what I'm calling butterfly politics, this metaphor, means that the right small intervention in an unstable political system, like air, something moving, can ultimately produce very large, complex reverberations leading to transformative systemic change. And also, it struck me that male dominance, is usually considered as being as inevitable as weather. And actually, we've changed the weather more than we've changed male dominance without even trying. So it seemed to me there's a certain fit in all of this. This butterfly politics idea then is a metaphorical attempt to understand ways that strategic intervention can produce systemic transformations in particular, the gender system. So it highlights some crucial dimensions of legal political activism, including the domain of the action, the strategic choice of moments of initiation, the dynamics of the ways one intervenes, including the blowback that you encounter, the collaborative effects of collective repetition. Doesn't work without that. And also a simultaneity of both retrospective and prospective causality. That is, there is no linear time in this. It's an ongoing, non-linear, active interaction, temporally speaking. So the first time that an idea or an intervention shows its face in public, I call its butterfly moment. This is the small perturbation, the consequences of which turn out to be variously large. And I'm going to predict right now that the public interest litigation that was initiated on behalf of APNEAT by Tinku and argued as a lawyer by now Justice Mishra is precisely one of these butterfly moments. As to the nature, and I'll say more about that as I speak here, as to the nature of the domain, if any social system, now we have to figure out, here's this public interest litigation intervening in an unstable political system. So how is it that this is the right domain? How is it this is the right intervention? How is it this wing flap is going to produce these complex reverberations that will produce change? So as to the nature of the domain, if any social system is complex and unstable, it is sex inequality. It's complex because, among many reasons, of its simultaneous multiple interacting variables, which prominently include caste, class, race, ethnicity, religion sometimes, disability also, sexuality, age, and gender. Now, all of those do a lot of their work through gender. And our last girl personifies them all in her own being. That is, the most unequal, depending on where she is living, on the basis of race or ethnicity or class, caste or religion, and age, also age. All of those factors make sex inequality complex in a multiple in multiple intersections, so that it isn't just one inequality we're dealing with here. It's a complicated interaction of many of them. All of those are inequalities on their own, but they also do a lot of their work through gender. And gender does a lot of its work through them as well. Gender, of course, analyzes men as well as women. I think that gender inequality is intrinsically unstable as well as complex. And this is true, not the least because it is predicated on a lie. Anything, in society that's predicated on an outright lie has to be unstable. And the lie that gender inequality is based on is the lie of women's natural inferiority to men and men's natural superiority to women. This hierarchy that is social, termed typically difference, the gender difference or the sex difference, in common parlance and sometimes in law and theory. I think that life, if it was given half a chance, refutes this lie every day. But that only means that it takes a lot of force to hold it together. This system for structuring and distributing power, this particular hierarchy of status and power, is a political one. If politics is seen as defined by power-structured relations. In the face of a lot of evidence and disagreement about its false basis, and a tremendous amount of international law recognizing that this is an outright lie, this inequality, and even a lot of acknowledgement of its injustice, it has proven extraordinarily tenacious, highly stable. Its real genius is its ability to change ground across historical time, across cultures. It adapts itself to every society in its own particular way, so that all kinds of other changes happen, but this continues consistently not to change. So, in order to change this through law, you need to accurately identify the content of the system into which the legal intervention is contemplated. This is going to be crucial. So, what is the air, by analogy, the equivalent of what it is the butterfly moves when it flexes its wings? In identifying this domain, I think that a lot of the work for sex equality has failed. Or in any case, it's been addressing mainly symptoms, which do need to be addressed, but they don't go to the roots of the problem. I think that mostly the conventional approaches to sex inequality, which revolve around ideas of sameness and difference, are women the same as men, or are they different from men, which is actually irrelevant, since if women are different from men, men are different from women too, actually, equally different. They just aren't equally situated according to those differences. That approach, which was created by Aristotle actually a long time ago, and it's time we gave it some more thought, usually doesn't face that the key dynamic isn't a level line unequally divided, into which this is Aristotle's image, in which we just need to slide some of the things over from one side to the other. Actually, it's a hierarchy. It's more like a ladder with interactive symbiotic dynamics happening within it, a top-down, bottom-up relationship, which isn't just like a two-cell table, some people are here and some people are there. It's graded and has a lot of dynamic interaction throughout it. If one sees sexism this way as the hierarchy of men over women, and actually the hierarchy of men over some other men, and this includes men of disadvantaged castes, it includes disadvantaged and excluded religious groups, with some men over other men. It also includes straight men over gay men, and the disadvantage of same-sex sexuality, and gender non-conformity in general. In white supremacist societies, such as the one I come from in the United States, it also includes the hierarchy of white men over all men of color. And also, of course, as you're aware, tends to operate internationally, with white male supremacist nations dominating over nations of color as they are seen in white supremacist ideology. So what I think is that conventional approaches haven't addressed either the fact that it's a hierarchy that we're looking at here, and that some people benefit from being on the top of it, just as other people are harmed by being on the bottom. That's part of what gives it its stability. But it's also the case that conventional approaches to gender have largely avoided the key lived place that it operates, where male dominance is, at least in many important ways, played out. And you see this in the life of the last girl. And that place is sexuality. Legal strategies, I think, that prefer to contend with dynamics that aren't what is driving things on a terrain which isn't where they are principally being driven, because people think that produces less opposition, or it's more pleasant for activism, or maybe even you win some cases, but what have you won when you've won them, is the question. That can do some things, but it can't fundamentally alter the dynamics of the problem, especially when they are structurally entrenched, as these are. By analogy here too, I think weather models wouldn't work either if scientists ignored small, consistent rises in global temperature because they just didn't like thinking about climate change. So dominant approaches to inequality have misdiagnosed the nature of this system, I think, including the way that it treats the status quo baseline as if this is natural, as if the last girl's existence is an essential feature of her. It's natural to her and inevitable for her to be located in the social position she is. Another dynamic that is common here is the gaslighting of survivors, particularly of sexual abuse. That is, telling them that what they experienced isn't real, that what they know happened didn't. I mean, Ruchiraji explained this when people started responding to what she had reported was done to her, telling survivors that it must have been their fault or an expression of their true nature in some real way, and or it didn't really happen. So while all this has gone on, some quite substantial changes have been made in sex inequality through law, through actually very unconventional, unprecedented approaches in locales that no one necessarily expected, and with no institutional backing whatsoever, specifically actually by me. So I'm going to talk about some of those. And the legal claim for sexual harassment, which was initiated in the United States, with a really full theory of substantive equality embedded in it and growing out of it, shows this entire dynamic. And you see it now jumping from law to society in this hashtag #MeToo phenomenon, which you're probably seeing. as possibly also a backlash by women to the election of an admitted sexual predator to the presidency in the United States. This approach saw through the entire likes alike, unlikes unalike approach to inequality, and has the larger theory of substantive equality in it has been accepted in Canada. Actually, of course, the Supreme Court of India has taken a quite similar approach in its cases on caste. The Canadian court has based, instead of looking for sameness and difference, it is looking to promote the equality of historically disadvantaged groups on concrete grounds, of which the last girl is the quintessential example. Now, people often ask me, why has sexual harassment law worked as well as it has socially, as well as legally? How do you produce social change through legal change? I think it's partly because sexual harassment law strongly illustrates another central dimension of chaos theory, and that is what it calls sensitivity to initial conditions. If you're in a non-linear, non-mechanical system, which I think law is, even the smallest shift in conditions at the beginning, such as the facts of particular cases, and certainly the choice of doctrine, can produce really big, dramatic changes in the long term. So you've got to get it right if particularly you're in a system that's neither linear nor mechanical. Now, if you see it I think the common law is actually quite a promising sphere for this kind of development. For agents of social change, knowing that extremely small initial conditions can be amplified in a huge percentage over time through systemically being repeated, which is what happens in a legal system, to ultimately radically shift the way a system behaves, presents both the risk and the caution as well as the hope of this approach. So the point here is it's crucial to set things up right from the beginning. Sexual harassment as a legal claim for sex discrimination faced the fact that its domain is sexual. This is what no one wanted to face, that is to say, it's unequally gender-based, and no injury of sexual violation had ever in law been faced that way. It had never been seen as unequally based on gender. In other words, a human rights violation on the basis of sex. Never been done, okay? But because that actually is what this is, it has had the consequences for social change that it has had. That is, when a problem is located legally in the domain that the problem lives in social reality, what it means is that the legal claims themselves will succeed repeatedly because their actual evidence will support the theory on which they're based. Now, this is almost too simple for really smart people to understand, it turns out. Because, sure enough, over time, legal and political ups and downs across cultures, this whole basic paradigm of harassment law as sex discrimination, including in India, has largely held. And it changes law, it changes politics actually as well as law, and opens courts to survivors in ways that never would happen before, and has produced a defining of sexual harassment as not just life, which is how it just was something that we had to live through before this. It is also extended in this instance to men as well as to women, so that when men are sexually harassed by men, even though that wasn't the original paradigm, that has now been successfully reestablished that as a form of sex-based discrimination. And it has also come to be, is beginning to be extended to establish gay and lesbian rights as such, not just in sexual harassment. What you're seeing in the response to women's disclosures of men's violations of them in employment all around the world now, as a consequence of what was initially established as, well, initially revealed really in Hollywood, is what we call in law voluntary compliance. So that there are very few, if any, legal cases being brought as a result of all these disclosures. But if sexual harassment hadn't first been made illegal, none of this voluntary compliance would be taking place. So, as I'm saying, essential for accessing this dynamic is calling problems in law what they are in life. And what we see in the PIL that was brought in Bihar, in the opinion by Justice Sinha, in the Patna High Court, is it called prostitution what it is, that is sex trafficking, under Article 23 of the Constitution of India, meaning, together with the Palermo Protocol to the Transnational Organized Crime Convention, interpreted together with it, based on the accounts of people who had been prostituted. The recognition is that prostituted people being coerced either by other people, that is traffickers or pimps, your father or other family members, and social conditions together, that is social conditions of vulnerability together with other people, or one or the other, is a form of coercion that means that prostitution is accurately seen as sex trafficking. And this was also in enforcement of Section 370 of the Indian Penal Code. For the last girl, this begins, as I know you know here in Bihar, at age 9 or 10. There are some other examples of social change through legal developments that can be seen as parallel to this one, and as this one comes to be known more throughout the world, I think we will be seeing further reverberations from it. But the idea of rape as torture in international law became established as an international norm in a very similar way. Another instance is the international definition of rape, which was predicated on coercion. That is, rape being defined in the International Tribunal for Rwanda as a physical invasion of a sexual nature under circumstances which are coercive. And that's actually what rape is. And you will notice that the notion of consent was regarded as so irrelevant as not even to require mention. I mean, if a physical invasion of a sexual nature is imposed on a person under circumstances which are coercive, why are we then asking her, in addition, didn't you really want it? That definition has survived repeated attempts to ignore it and has been incorporated into the elements of crimes at the International Criminal Court and is expanding all around the world. I mean, the whole development of the notion gender crime of which the PIL in Bihar is a beautiful example, is expanding on the international stage. The theory of substantive equality premised, as I mentioned, on hierarchy of historic disadvantage is another excellent example, and you can trace that through the Supreme Court of Canada. The legal theory of social change that emerges from this whole analysis is not simply deterministic, as a lot of legal realism would teach you, nor is it cynically despairing, as much critical legal theory might lead you to believe. Traditional theories, whether they are old or new realism, or public choice theory, or pluralism, for example, tend to be reductionist, linear, unreflective of social complexity, and not adapted to the substantive realities of male dominance. What you see instead is people on both the right and the left bemoaning unintended consequences. Now, of course, you have to consider the consequences. However, as I thought about this endless counsel to do nothing, it has seemed to me that not only have I seen few, if any, negative consequences of my work, but I think that in the context of this analysis, that consequences you did not necessarily anticipate would only be a really big surprise to someone who had never, by supporting prostituted people who want to leave prostitution, which by international measures is 92% of them. And as mentioned also by Lucina, it now exists in many countries in the world, including Canada, and is championed by APNIAP here in India, having the possibility of adding a crime of buying a person. The buyers are the people with the real power in this picture. The pimps and traffickers are often of the same disadvantaged groups, they're men typically, although sometimes women as well, as the people who are being sold. That doesn't excuse it, but it does help explain it, since they are also being discriminated against in terms of having other life options for their survival and that of their families. The people with the real options, the people who are doing something that they don't have to do, are the upper caste, upper class men with the money who form the demand, which is the reason why prostitution exists. They are the people who are the real, or as one woman put it to me when I was here last in 2009, why don't they arrest the real criminals? You know, these are the people who are the real criminals, are the buyers. So some of these initiatives are all moving in the right direction, which includes the awareness of rape as genocide. Some of these changes are in the process of being progressively accomplished, such as the Nordic model on prostitution or the equality model. And all of this work is based on the experience, as the PIL here, is based on the experiences and needs, actually demands, of survivors who initiated all of them and have produced the worldwide movements here. A couple of points that I would notice here where the so-called butterfly effect is just beginning would be in the law of rape itself. As I mentioned, with the definition of rape in the International Criminal Tribunal for Rwanda, that was the Akayesu case, is predicated on coercion. Consent being irrelevant. No domestic law of rape has taken this approach. What I would urge you to consider is that making consent central to rape law is what puts the victim on trial. It's why the British conviction rate, British actually are the ones who spread this consent everywhere they've gone in the world, including the US and here. British law has an all-consent rape law. Their conviction rate is an appalling 6.3% of cases brought. As a concept, consent is rooted in the active-passive model of sex as being something that someone with more power does to someone with less. It is thoroughly sex stereotyped. It's given its fullest expression in the political theory that justifies rulers in ruling the ruled. This was the obsession of British political theorists in the 17th and 18th centuries, justifying the rulers ruling the ruled, and consent was their rationale for that. What it essentially means is acquiescence, whether or not a choice is real in the context. The last girl has no real choice, yet consent is attributed to her, especially the moment that she becomes 17 years and 366 days old and is suddenly now a consenting adult. Consent means being rolled over by power. It's an intrinsically unequal concept, even when it works the way it's designed to work. By contrast, the international law of sex trafficking prohibits sexual exploitation, as you know, in circumstances of vulnerability or abuse of power, and consent by statute is irrelevant and has been since 1949. So what are we doing here? We're building a law for serial rape, which is prostitution and sex trafficking, in which we understand circumstances of vulnerability that make consent irrelevant expressly. Meantime, consent is supposedly the big new solution to the law of rape, in which we are to be, there's going to be two rape laws now. One for prostituted women, where vulnerability is recognized and consent is seen as irrelevant as it is, and another one for everybody else, in which conditions of vulnerability are not recognized, and consent defines what the crime is. Sexual harassment law, by the way, and equality law does not use the concept of consent. It uses instead the notion of welcomeness, which is an entirely different idea. That is, if one actually welcomes an interaction, it isn't the same thing as being rolled over by power. It could have not worked well, but surprisingly enough, even in the US, it has actually worked very well. I mean to say that inequality is not consented to. That, for example, if one accepts unequal pay, say you're paid half of a woman, say you're a woman and are paid half of what a man is paid, and you accept that money. That means you've consented to accept the money. It doesn't make it equal, does it? If you see rape as a crime of inequality, consent needs to come out of it. And domestic laws of rape need to be based on coercion. Reconfiguring definitions of force to extend beyond mere physical force to all the forms of inequality that make rape possible. All the situations of which the last girl is the quintessential instance. That is, caste, race, class, sexual orientation, gender identity, disability, and age, as well as gender stereotypes. When all of those are actively deployed in an interaction to force sex. So now, in case you were wondering what there is left to do, except everything I've highlighted so far, there is a continued virtually total impunity for sexual abuse of children generally. And this is true worldwide. And I would just like to note that I think sexual abuse of children is arguably the foundational practice of the whole gender system. That sexual abuse in childhood, that is, being in the position not only of the last girl, but the first girl, any girl, this can happen to, and little boys, is ground zero of sex inequality. It's the foundation of prostitution and sex trafficking, in that most people used in prostitution were sexually abused as children and entered prostitution as children, or prostitution is their first sexual experience, and it is an experience of rape, often gang rape. It's also the case that both children and most prostituted people sustain serial rape and molestation under circumstances in which they have no real options. Sexual abuse of children is also what rape and sexual harassment and prostitution are all about. It's all the same dynamic. It is sex being forced on those who have less power by those with more. That is the dynamic of it. And that's the dynamic also that pornography sexualizes. And many, if actually most, rapists were sexually abused as children. And there again, it doesn't make it acceptable what they do later, but it helps us to explain and understand these dynamics. So to escape being raped as they were as children, which is a choice men are given, many men become masculine, including toxically so, sexualizing their power over others. And to survive under this system, girls are taught to acquiesce in femininity, sexualizing power over us, in hopes of a somewhat better position under this system. So sexual abuse in childhood, to which the last girl is the one who is most vulnerable, explains more about the gender system, that is, more about male violence, meaning violence, and more about sexual politics, meaning politics, than any other single thing does. If you put together the good studies on this, it affects about half of all girls in the United States in contact forms before they reach the age of majority, and at least a quarter of boys, where the studies are not as good, but we know it's at least a quarter. And there have been some steps taken to do something about it, but very, very few. So, as all this illustrates, each of these important initiatives where real change for social change through law has been made began with survivors' lives, as it did with the PIL here in Bihar, called narrative in scholarship, facts, actually, in cases, about which essentially nothing was being done, called impunity, followed by the first movement predicated on a relationship between a survivor and organizers like APNIAP and advocates such as now the judge, who were awake and then unsettled the waters in what appeared to be an isolated local setting. And this is what I think the real lesson here is that if survivors trust you, there's nothing you can't accomplish. The major lesson, I would say, about law's power to make change, and here the change involves recognizing sexual abuse as a human rights violation. That one's sexuality is a place in which one's humanity resides and also can be taken away. Okay, that idea, which had never happened before and underlies all these initiatives. that doesn't come from law's place in the existing order of power. People seem to think that it's because law is powerful that it can do these things. I think that's completely wrong. I think that law's power is what resists these changes. That the power to change here comes from law's location in social life, that is, what it means to people, the meaning that people give to it, including especially people who aren't equal under it, even people for whom the law doesn't deserve the meaning that they give it. That is, it's not because of its place in the established structure of force or authority, or because it creates precedent that then binds other cases. And it isn't because it's a vehicle of state power, and so it can impose itself on life. I think law can change reality because people believe in it, including people that it hasn't represented. This is why even a small percentage of women report their rapes to the legal system. This is why they feel vindicated when the law believes them. It's why they feel shattered when it doesn't. It's not because they're naive or blindly trust it or have an illusion of living in a just world. It's actually, and this is the women and the men who provided their accounts that underlay and produced the awareness in Bihar's public interest litigation. They're not naive. They don't blindly trust in the law. They're just determined to stand and fight for themselves, for, and even more for others like them, with a notion that the law can be a weapon in their hands, and also with a principled insistence that it represent them and people like them for a change, as, by the way, it gets its legitimacy from supposedly doing. It's why these victims of intergenerational prostitution by caste in Bihar brought this litigation, and why they asked to have the law actually applied to them, to protect them and their families, to give them real education and support, to provide for the victims in this form of abuse. One caution I would leave you with is that it's easy to resist gains for women by law because law provides what appears to be a principled legal cover for male dominance, because male dominance has created law to this point. So, for example, speech provides cover for the abuse that is pornography. In the United States, property provided the cover for the system of white supremacist racism. I think that consent provides a good bit of the cover for both prostitution and rape. But social change through law for women is not what extrapolations from Marx have thought. You know how Marx thought that the worse things get, the more likely a system is to be forced to change? So, like, let's let things get worse and worse? I think women's reality is an awful lot more straightforward. The worse it gets, the worse it gets. It actually becomes harder to change, not easier, the more entrenched it is. So, I would say not to listen to that particular idea. The power of political law for women ultimately comes less from the law than from the women and the politics. It's why when you talk the substance of reality about sexual abuse to judges, it's why it is effective. It's been almost entirely covered up, and when it's opened to the light of day, it looks like what it is. Denigrating, devastating, disruptive, and denying the victim's humanity, being defended as if the perpetrator has a right to do it. When you go after legal change in this way, it's empowering, not disempowering, whether you win or lose. One thing finally to say about what law means to women. I think this is widely misunderstood. It doesn't provide what is called closure because it can't. It isn't meaningful because it can order incarceration, although sometimes this is necessary. But incarceration does very little right and a lot wrong. And it's not only that it provides money damages, whether it's deserved or not, because no amount of money really compensates. It also can't bring back a murdered child or unrape a woman or girl. Law's power to change lies in its capacity to restore a piece of the humanity that the victimization took away. It's this possible chunk of wholeness, this hope for it, this we believe you, we are with you. This is the power that gives lawyers for violated people the ability to change. In isolation and in image, butterflies are delicate. They're even fragile. They can be overlooked or reduced to decoration. In life, their endurance lies in their collectivity, and their power lies in their collective effect. So I say, equality seekers, spread your wings. You're a lot stronger than you know. And what butterflies can set in motion cannot be stopped. When our last girl, the one who is our butterfly, opens her wings, when she can fly, she changes the world. Thank you.
Thank you, Professor Mackinnon, for an enlightening address. I'm sure all of us will take a lot from your address and we'll have a lot of thinking to do after this. The floor is now open for questions, and due to shortage of time, we'll just be taking 5 questions. And I would really request you to
questions.
And this question, or rather maybe a question to Professor Catharine, I wanted to ask you something like, what's your view on organizations who promote pornography in the US, back in the US, and then they use the same money here in India or Vietnam or any other country for family planning or any other social work? Since you started talking about pornography and US, so I thought maybe you would be the right person. It's a moralistic question, but I thought you would have an answer to this.
Definitely had gained a lot of insightful perspective. One small question is that how do you deal with the judiciary, especially the judges? And I'm sorry, I do not wish to offend any of the judges, honorable judges sitting here, who have actually imbibed the notion of consent from the very beginning, starting from their legal career, and now they have moved to much senior levels. For them to comprehend the idea of consent vis-a-vis cohesion, how do you deal with this contrast? Thank you.
Argued that there will be 2 different sorts of laws as regards rape, one which is centered around coercion and the other which is centered around consent, and how you argued for the one centering around coercion to be the one which should be tried to be aspired towards and achieved. How does that law eventually pan out in the courts? Because consent is the method of examination that courts tend to examine. Did the woman consent or not? Which is putting focus unjustifiably upon the woman. But when the narrative is surrounding the idea of coercion, what will be the method of examination and investigation that the courts will then employ?
My question to Professor Catherine is based on a little bit of a fundamental point which I have discovered, is that when we're talking of such phenomenon, whether it's child labor, sex trafficking, a lot of it begins from the social environment which was spoken about. The social environment is a huge contributing factor. So let's say if there is a certain perpetrator of any such offense, what exactly have you seen people taking a different approach in rehabilitation? Because if, let's say, there's a particular offender, for them to be integrated back into the society is something which is very, very difficult. So what are the different approaches, what are the impediments, or what are the success stories that you may have come across in your work so far?
Hello ma'am, I had a question regarding something you said in your speech. When you said variables like sex, caste, class, etc. play out through gender, you also referred to the vice versa situation. So what exactly did you mean by gender playing out through these different variables?
It is mine, it is original, it is new. You've never heard it before because no one's ever said it before. So it isn't in effect anywhere. I can't explain to you, I can explain to you how it would work if put into effect. And that is all the inequalities that produce the grounds for the coercion would be the source of, and their deployment in a particular situation would be investigated through law. And you can look at Harvard Law and Policy Review of summer 2016 for 50 pages worth of my talking about this, as well as a statutory proposal at the end. Also, the 12-minute version is in my book. The elevator talk is in collected in Butterfly Politics, this new book published by Harvard University Press, which is available on Amazon and is sold in India at what is a very good price worldwide, at least.
It's on sale outside just now.
It's on sale outside now. Okay, I would love to sign a copy for you. And I love signing my books because I actually did write this for you. And this allows me to make that manifest, you know? So that's in there as well. On judges and consent and all, judges can take in new ideas, but this is a new idea. I don't expect them to have already understood it because all they've ever been taught is the opposite. That, you know, this is what freedom for women really looks like. I say this is what inequality for women really looks like. And they are fully capable of considering it and understanding it, but also existing law says what it says. You know? So that needs to be reconsidered by the appropriate authorities without putting any particular burden on judges in specific cases. The question about rehabilitation and integration, I would just refer you to APNIAP's excellent assets approach to the empowerment of prostituted people. It has 10 particular steps that definitely aid in motion toward reintegration in society, and also the education of young girls, removing them from coercive environments in which they are to be trafficked, and receiving an actual education is I've observed it to be highly successful here as well as elsewhere. I don't want to be too Pollyanna-ish about this, in that I've worked with a lot of women in pornography who were violated in it, and some of them have done extremely well later on, some much less so. So the damage is severe, and in particular when pornography is made of your sexual violation, it's permanent. The pornography is always out there, and that has a tremendous effect on the ability of women and girls to live their lives past that. The women I've represented have struggled with that, some highly articulate ways, and advanced their own lives, but it isn't ever as if it didn't happen. The trauma of it is accentuated, is multiplied by knowing that at any time some man can go see you being violated that way. And this is true for adult women who, as girls, were violated in child pornography. The pornography of them being violated is still out there. And the notion of rehabilitation shouldn't just come gently off your mouth, without thinking about the nature of these industries and the ways that they make permanent this violation, and people continuing to enjoy it. Dropping, used to be the loops, you drop some money in and watch her being violated. Now you just go online. So the effects of that can be overwhelming and recurrent. Even though I know many, many women who have struggled for years against it, with what I would have to say is inspiring tenacity. And also I would add to that just that really actually working for change in this system has been something that has made a tremendous difference to survivors, and the movements I work in are all survivor-led. The pornography work was all survivor-led. You won't hear that anywhere else, so you're hearing it now. And most of the people in it, other than I think 2 of us, had formerly been in prostitution. And that includes Andrea Dworkin, was. And so that's how we knew what we were talking about in the pornography work. And all the work against prostitution has emerged from those people those women who originally did that work, and then began going deeper into the industry that produced it. That is, pornography and prostitution are 2 arms of the sex industry, and pornography is a form of sex trafficking. So it goes on in that way. The question about organizations that promote pornography in the U.S. and then do what here?
They give support to international NGOs. They provide funding.
Okay, so abuse of women. These entities that are connected with pornography in any way have more money than God. I mean, they have an unlimited amount of money. I mean, that's their resource because of the ways that women are violated to make it. And so anything that can be bought, they can buy. Okay, turns out they can't buy us. But there are many organizations that they can buy. So how did the word moralistic come into what you asked me?
Personally, any work here? That's what I wanted to
I
ask.
see. Well, I would have to look into what the pornographers are specific, how they are being active in India. However, taking money from pornographers, it should just be pointed out, women paid for that money. Women are being violated, so they have that money, and whatever it goes into then subsequently, they are attempting to buy support for a system that continues to violate women through the granting of those funds. That is how they work. Okay? It's a business, and they expect a return for the money that they provide. So I would say to that. The question about gender playing out through, say, class or caste issues. The reciprocal ways these work, for example, if you look in pornography, there are women who are being presented as high class because that's the women some men want to buy. Or you look at the prostitution, the way prostitution is played out, concubines, so-called, escorts, all these are forms of prostitution, but they're given a high-class wrap-up because the men who want to violate those women want that as part of the product. So gender plays out through class in that way. It doesn't mean those women actually have high-class options. It's just that the men who use them are able to imagine that they do, and that facilitates their use of them, usually for money going to a larger organization, and they get some percentage of it. So, I mean, that's just one example. The rape of enslaved women in the United States is another example. The way the slave well, you know the term African American. The reason that almost all African Americans are of mixed race in the United States, I mean, there's good reasons and bad reasons. I'm talking about the bad reasons. The good reasons are that people love each other and make families. The bad reasons are that from the beginning of slavery in the United States, white owners raped black women, and the children produced through that rape were then considered enslaved children. And that is, they were amazingly considered the children of their mothers. This is the so-called one-drop rule. You have one drop of African blood and you're considered black. Some people passed, as we call it in the US, so go, depending on how white you look. But those children were the property of their father because they were the product of an enslaved mother. That shows you how the system of racism through rape reproduced property ownership in human beings on a racial basis. Okay, so that's how gender, which is rape, of which rape is an act, was integral to the property system of enslavement. That's just an example of, another example of how gender plays out through race.
Socio-academic discourse, it's my privilege to propose a vote of thanks. Since it's already 6:45, I'd rather brief. Please don't take the brevity of my presentation as an indicator of the depth of my thanks. I first thank profusely Professor Mackinnon. Most of us, if not all, when we join a social cause, we normally join it from out of compassion. Okay, we are human beings. Somebody else is suffering. We must stand by him or stand by her. That's good enough a first step, but that compassion does not take us far. All that we do in this field of social progress or any other thing has to be supported by enough of theory, enough of legal backing, enough of social practices, and so on and so on. Number of people who are able to make contribution in this field okay, theorization of the process or legal aspect of the process is much smaller, much smaller. We are extremely grateful that Professor Mackinnon is one of them. And I also realize that he is not only good, but one of the very best in the world, I was told. And some of the contributions she has made is outstanding. We are extremely grateful, Professor Mackinnon, that you are in Patna and we have been benefited by your advice. This session was also, we had the presence of MS Justice Anjana Mishra and Mr. Justice Ajay Tripathi. The whole purpose of bringing them over is that this is a legal discourse that we are trying to do, and we should have some of the most important legal luminaries from Patna in the day. For both of you, I have very deepest thanks for the initial comments that you made to make us understand the challenges we're facing in the Indian context or in the Bihar context. Before this session, we had another session before tea, where the opening remarks were made by Dr. Ruchira Gupta. Ruchira is not new to us. She has been here many times, and we are yet again enlightened by another presentation by her on the difficult challenge of trafficking, the last girl, and the general problem of women's status in the society. We are actually thankful to her. But besides her, we also had a presentation by Dr. Nadeem Noor. Unfortunately, because of time, he couldn't make the full presentation, but it was a brilliant presentation based on some of the very hard facts, NHS 2, NHS 3, and NHS 4. Most of you who are in this business must know that NHS 4 has already come. Even the Bihar results have, the detailed results have come. And comparisons over the 3 or 4 ones give us some excellent ideas at which pace and which direction we are proceeding so far as the women welfare is concerned. We are also lucky when it comes to doing something for the social change. You can't do without the administration. So we are very thankful that no less than 3 persons were here, Mr. Deepak Kumar Singh, Mr. Vijay Kumar, and Dr. N. Vijay Lakshmi for their kind presence in the seminar. This seminar is all the more important because the sittings I have many friends in this gathering. It's not going to be possible for me to name all of them, but let me mention especially Ms. Sinisha Jha, Mr. Satir Singh, Mujibur Haq Sahab, who is not there, he has left, and also Priyadashini ji, one of the people who is working in this field. The host for this function were 3, Adri, Apne Aap, and General Alliance. Since they are hosts, I did not thank them, but that will be too far. I must thank especially Apne Aap, especially Dr. Ruchira Gupta. Without her initiative, it would not have been possible to hold this meeting here and also have Dr. Professor Mackinnon here for this. Ruchira, thank you once again. I also thank her colleagues Tinku Khanna and Anahita. From General Alliance, we have Prashanti, Manisha, and Dina. All of them have been working for last fortnight or so, at least last week, very diligently for making this occasion a success. Thanks to all of them. At Adri, well, Shaibala was there to overlook everything right from the beginning. And as usually, he was supported by Dr. Sunita Lal. Thanks to both of them. And another important hand in the whole business was Rajesh. So thanks for Rajesh also. With these words, I thank you again, all of you. And we have some next meetings somewhere. Thank you.